46 मैं स्टार्ट द केस. Organized crime by declaring allied pupil dead to fraudulently grab their property. Shri Lal Bihari, a school teacher from Anzampur district, UP. He had running feud dispute with his uncle who wanted to deny the Lal Bihari's legal title and fraudulently grab his ancestral land. After due consultation and perhaps some legal expert, his uncle hit upon an idea which only a trained mind in government affairs will come up with. In the year of 1976, he hatched a criminal conspiracy along with some revenue officer and consequently he got a certificate from the Tehsildar concerned that the school teacher Lal Bihari was dead. Shri Lal Bihari was not aware of the fact that he had been officially declared as dead. In 1976, Lal Bihari was in the process of applying for a loan from a bank against his land. When the bank representative delivered the bad news, he became alarmed when he was informed that as per the revenue record, he was dead. And it was not just that his loan had been denied. He was clearly a breathing, animated, yet government records indicated that he was no longer among the living. There was even a death certificate bearing his name.
Good morning, sir. Lal Bihari told revenue officer that he was alive. After discovering he was listed as deceased, that may be so. A killer replied, but according to my book, you are dead. There was no argue that he appeared to be alive. But such evidence turning out insufficiently to correct the error. After some hunts, Bihari learned that his situation was not due to some administrative blunder or error, but rather it was due to an act of fraud. His uncle has bribed some government employees to provide a fabrication death certificate as well as bribing another fellow at a local land registry office. The uncle has gained the legal title and to Lal Bihari's land, leaving no legal living soul to challenge the claim. As Lal Bihari began to lengthy effort to bring himself back to his life and reclaim his stolen land, he discovered that there was many other like him and that the death by paper practice was just widespread in a region of India is known as bad land. This was an unusual exercise but ramped in their days. It was easily to declare a person dead by coddling with authorities. After the official declaration, all the movable and immovable assets were transferred to the legal heirs.
Good morning, sir. As the prosecution charge according to section 120 of IPC, there is a criminal conspiracy between the uncle of the accused and revenue officers. There is no any criminal conspiracy because in criminal conspiracy there are two main essential ingredients, which is illegal act or act which is not illegal means. And in both there is not any criminal conspiracy. A mere breach of contract does not necessarily amount to cheating unless there is dishonest or fraudulent intention on the part of the accused at the time he induced the complainant to enter into a contract and to part with and property. And also defending against accusations involves maintaining honesty and transparency. Just above, every state will grant access to a core group of authorized individuals. This will typically include family members of the deceased. Due to his family members not being present, his uncle had got the death certificate made. The death certificate is a medical opinion regarding the course of death based on the available information at the time of the death. Presumption of death. A presumption of death occurs when a person is believed to be dead despite of absence of direct proof of person dead, such as finding remains attributable to the person. And such a presumption is typically made by individual when a person has been missing for an extended period and in the absence of evidence that the person is still alive, but where the circumstances surrounding a person disappearance support the belief that the person is dead. The person become certainly honest, being located a period of time that he has exceeded their probability lifespan. In India, presumption of death is governed by Section 107 and 108 of the Indian Evidence Act, which allow for presumption of death for a person missing for 7 years to be raised in appropriate proceeding before the case. Here are some related cases. In the state of Kerala versus Fareed Pillai and others, a 2-judges bench ruled that hold a person that guilty of the offence of cheating, it has to be shown that his intention was dishonest at the time of making promise, and such a dishonest intention cannot inferred from a mere fact that he could not subsequently fulfill the promise.
Section 108 provided that where the question is whether a man is alive or dead, and it is proof that he has not been heard of for 7 years, or for those who would naturally have heard of him if he had been alive. The burden of proof, the proving that he is alive, is shifted to the person who affirmed it. The privacy council further observed that on this aspect, the English law and Indian law were the same. There is no presumption that a person not heard for 7 years should be treated as death on the date of expiry of 7 years. Hiralal Bhagwati versus CBI. The complainant is required to show that the accused had the fraudulently and dishonestly intention at the time of making promise or representation from his making failure to keep promise subsequently, such as a capable intention, right to the beginning that is at the time when the promise base made cannot be presumed.
After making all the efforts before the police and revenue authorities, the aggrieved person may file the complaint before the learned magistrate under section 200 of CRPC. Thereupon, magistrate would record the statement as contemplated under section 200 on oath. Under section 120B IPC's criminal conspiracy, he had criminal conspiracy along with some revenue officials, and consequently he got a certificate from the Tehsildar concerned that the school teacher Lal Bihari was dead. Under section 420 IPC, cheating and dishonestly inducing delivery of the property. His uncle had bribed some government employee to provide a fabricated death certificate, as well as bribing another fellow at local land registry office has gained the legal title to Lal Bihari land.
His uncle not bribed any government officers. In the case of Rekha Jain versus State of Karnataka, held that to make out the case against the person for offence under section 420 of IPC 1860, there must be dishonest inducement to deceive a person to deliver any property to any other person. As per section 420 of IPC, whoever cheats and thereby dishonestly induce the person deceived to deliver any property to any person can be said to have committed such offence.
Under section 267 and 268 IPC, making or selling false weight or measure or public nuisance, as Lal Bihari begins to lengthy efforts to bring himself back to life and reclaim his stolen land, he discovered that there was many like him, and that the death by paper practice was widespread in a region of India known as Bad Land. There was a usual exercise by dreamt in those days. It is easily declare a person dead on coddling with authority.
Sir, there is no medical negligence, we can say, because there is a case, Srimati Rani versus Chief Settlement Commissioner, Delhi. The High Court dealing with the death certificate observed as an administrative office doing the quasi-judicial work. The additional settlement commissioner was entitled to give a sentence to the death certificate. He was bound only to make a preliminary inquiry as settlement commission was entitled to give a sentence to the death certificate. He was bound. He was bound only to make a preliminary inquiry as to who was the heir of Nanak Chand. He did not have to decide the question finally. For the preliminary inquiry, the death certificate signed by the respective person of the place where the family relationship was sufficient. Thereof, the additional settlement commissioner was satisfied that the substitution of the sons of Nanak Chand is in place of the deceased would not prejudicial affect his daughter. It was not therefore necessary for him to have given an opportunity to the daughter of the heir under subsection 2 of the section 5 of the disappeared person claim supplementary act 1954. In the instant case of a certificate by certain respectable person of the place where the family once resides does not satisfy the requirement of section 35 of Indian Evidence Act. There is no proof that thus any statutory duty was cast upon the person issuing the certificate to keep a record of birth and death, and therefore the certificate of death has no evidentiary value. It is very easy for a person to obtain death certificate from the so-called respective person in order to grab the property. If according to the Devan Chand Nanak Chand has died, he must also indicate where he died, and it is the place of his death which will be relevant and not the place of his birth residence. The certificate obviously is not of the place where Nanak Chand died. We are of the view of the authority have greatly erred in reliance upon the certificate of death which was inadmissible in it.
Under section 471 IPC, using a genuine or forged document or electronic reports. Such evidence turned out to be insufficient to correct the error. After some hunt, Bihari learned that his situation was not due to some administrative blunder or error, but rather it was due to an act of fraud.
Sir, that certificate is a public document, so there is no conspiracy of to incorrect their death certificate, and there is a doctor who certified a person who is dead, who declared it as a dead. So that certificate then he generated the death certificate.
Because Shri Lal Bihari, a school teacher from Azampur district, UP. Shri Lal Bihari was not aware of the fact he had been officially declared as dead in 1976. Lal Bihari was in the process of applying for loan from a bank against his land. When the bank representative delivered the bad news, he became alarmed when he was informed that as per the revenue record, he was dead.
Is he earlier mentioned that the school he is going for school is not? Is he going for school? There is no document. He is going for school. There is no signature. There is no record to going school.
Lal Bihari told revenue officer that he was alive after discovering he is listed as deceased.
Sorry.
Lal Bihari told revenue officer he is alive.
So there is a document, no? There's a school. Earlier you mentioned that there's a document. He was going every day in a school. Okay, where is the document which can prove that he is going every day in a school? There's a mention of a document in the proper register, which is their registered their name and signature.
He is alive. He is alive because he is going for a bank for a loan.
Under section 108 of Evidence Act, there is provided when a person is disappeared from several years, it is considered as he was dead, or any government servant is declared dead without any insufficient cause.
For years, Bihari battles the bureaucracy and corruption in an effort to list among their life, finding that all the official channels lead to dead ends. Kidnapping his son, Lal Bihari kidnapped his cousin Babu Ram, through family bribe authority to declare his death. Lal Bihari, not being a seasonal kidnapper, did not know what to do, so he wanted to watch movie with Baburam every day. When the children family does not file a police complaint, Lal Bihari returned Baburam to his family.
Okay, so you mentioned that Baburam Lal Bihari kidnapped his own cousin. Okay, so why did Baburam's family why not file a case? Is they know about is they know Lal Bihari is alive or not? Why they are not filing a case? Is he kidnapped?
His uncle had bribed some government employees to provide a fabricated death certificate as well as bribing another fellow at local land registry office. The uncle had gained the legal title to Lal Bihari's land, leaving no legally living soul to challenge the claim.
He is also an influenced person. He did not need to bribery any government servants.
Or at that kind of property they want to grab it. They are already an influenced person, so they can easily grab the ancestor land. There is no need to declare a person to be dead.
Registers a false case with police for rioting. He bribed an inspector to register a false case for rioting on him. There was a plot to get noticed by the authorities, but when the inspector got to know his motive, he returned the bribe.
Return the bribe. So there is some kind of false case. There's a case. There's any kind of complaint which we are shown is alive.
Applied for widow pension, Lal Bihari came upon with the idea to apply a widow pension of his wife since he was dead in the eye of the law. He thought that while rejecting his wife's application for widow pension, the authority would admit that the husband is still alive. Though the application was rejected, but on some other technical grounds.
His wife know he is alive, so why he tried to pension it as a widow?
He thought that while rejected his wife's application for widow pensions, the authority would admit that the husband is still alive. So the application was rejected, but on some other technical grounds.
As I mentioned in section 108 of Evidence Act, there is no the burden of proof on the accused is to prove that he is alive. Otherwise, the government is also denied to alive that person.
Sir, is he alive? So there is a document. There is some kind of a known person who can see him. There is no person to see him. There is no particular fact. There is no particular document or something which is declaring he is alive or not.
Also, he is disappeared from several years. There is no evidence provided by the prosecution.
There is no relative until they know he is alive or not.
In another gimmick to grab attention and let the eyeballs rolling, the Lal Bihari decided to contest for Lok Sabha election. He had the courage and discretion to sell off his property and file nominated against Shri Rajiv Gandhi and later against Shri VP Singh. Got him the attention of a few media group who started writing about him. He went so far as to add the word Mritak, meaning dead, to the end of his name, the late Lal Bihari, created these public sense in hopes of being arrested and thereby forcing the government to acknowledge his existence. But each time he was madly beaten by police or rebuked for wasting official time.
You also mentioned that he fails to prove of a burden of proof in section 108. He attempts many widow pensions or in false cases. He may try to be he may try to be appear in several cases, but he fails. So the government is declared dead.
In case of Subramanian Swamy versus Manmohan Singh, 2012, Supreme Court held every citizen has right to file a complaint for prosecuting a public servant. Every complaint authority shall take appreciate action on a representing made a citizen for sensation of prosecution for a public servant strictly in according with her direction contained in Vineet Narayan versus Union of India 1998 and guideline framed by CBC in 3 months. The competent authority cannot undertake a detailed inquiry or decide whether or not the allegation made against the public servant are true.
So there is a case related with the fact. The state of Kerala versus A. Pavidi, Pillai versus and others. A two-judges bench ruled that to hold a person guilty of the offence of cheating, it has to be shown that his intention was dishonest at the time of making the promise, and such a dishonest intention cannot be inferred from a mere fact that he could not subsequently fulfill the promise. Similar view has been taken in the case of S.W. Palinkar and others versus State of Bihar and others.
Magistrate may also be requested that since the matter involved manipulation of government documents and government servants are involved in the matter be sent for inquiry under section 202 of CRPC to the police.
How can you say that many officers are involved with his uncle, even there is no proof?
Such evidence turned out to the insufficient to correct the error, but some hint Bihari learned that his situation was not due to some administrative blunder or error, but rather it was due to act of fraud. His uncle bribed government employees to provide a fabricated death certificate as well as bribing another fellow at the local land registry office. The uncle has gained the legal title to Lal Bihari's land, leaving no legally living soul to challenge the claim.
Sir, the Lal Bihari's uncle is a very powerful and influential person. He never done this kind of act because he is very powerful, so he can grab it easily. There's no need to just declare a person to it.
And then Lal Bihari also legal title and fraudulently grabbed his ancestors' land. I would like to represent my case with my colleague Avantika and Anushri. Bachchan Singh was a farmer from Punjab on July 31, 1979. He got into an argument with his neighbor Basant Singh over the watering of their crops. When the debate heated up, Bachchan Singh fatally stabbed Basant Singh. Into that same day, Bachchan Singh went to the home of Basant Singh, brother-in-law Darshan Singh, and stabbed him to death as well. Having previously been convicted for the murder of his wife under section 302 of IPC, Bachchan Singh served 14 years in prison. After his release, he resided with his cousin Hukum Singh and his family. However, this living arrangement was objected to with wife and children of his cousin on July 4, 1977. The accused convicted an atrocious act by murdering 3 out of 4 children of his cousin using an axe. Bachchan Singh was thus convicted for the offence of committing the murder of Desa Singh, Durga Bai and Veeran Bai by Session Court. He was given the death penalty under section 302 of IPC. He appealed to High Court, however the court dismissed the appeal and upheld to the death sentence.
Related case Kishori Lal versus Rupa and other. It was held by this court that in this case involving conviction and under section 302 of IPC, it is only in exceptional case that the benefit of separation of sentence can be granted the impugnant punishable under section 302 of IPC. The court should consider the relevant fact like the nature of accusation made against the accused, the manner to which the crime is alleged to have been committed, the execution of substantive sentence of imprisonment of life or fine 10,000 rupees imposed after finding them guilty for offence punishable under section 302 and with section 334 of IPC. And there is also some case Manu Sharma versus State of NCT of Delhi, also known as the Jessica Pal case, was one of the leading case, and terrifying death case led the clarity to know that sometimes many while anything just can't buy justice. In this case, the girl was shot to death when she refused to serve the alcohol to one of the accused. Her sister had to run all the courts for justice, and she led to having the suo motu cognizance taken to the High Court. The court is award him the punishment of life imprisonment.
Respected sir, I am representative of defendant and I would like to permission to present my case with my colleagues Palak Rawat and Nishita Gupta. In a section 302 of the IPC, in a case under section 302, the Indian Penal Code, the accused may have several defences. However, these defences are subject to strict legal and their defence are lack of intention of cause death. The accused may argue that he did not have the intentions of causing death and the death was a result of an accident or mistake. In such cases, the accused may be charged with a lesser offence such as a culpable homicide not amounting to murder under section 304 of IPC. Good morning, sir. Here are some related defense which is relating to the defendant. Self-defense. The accused may argue that he was acting in the self-defense with the Basant Singh and that he had caused the victim in order to protect himself to order from harm. Bachchan Singh must have proved that the act of causing death was necessary and reasonable in the circumstance after the debate with the Basant Singh and provoked by the Darshan Singh. Bachchan Singh may argue that he was provoked into committing the act of murder and his action were a result of the provocation. Such as the Darshan Singh insulted the accused or his family when the Bachchan Singh was subjected to the physical violence. After result, the action against the Darshan Singh was by the subject to the physical violence and that he was provoked into committing the act of murder and it can be raised in that circumstance.
Some related cases. Jagmohan Singh vs. State of UP. The unanimous verdict, the constitutional validity of death penalty was held and the court held that the capital punishment should not violate the Article 14, 19 and 21 of the Indian Constitution. In case of Ramesh Babulal Doshi vs. Gujarat State, the appeal under section 302 of the Indian Penal Code, whereby it was the acquittal of the appellant while upholding the acquittal of three others who were arraigned with him. And in Harkit Singh vs. State of Punjab, the trial ended in the acquittal of appellant under section 302 of IPC and as earlier could not be examined during the trial and no intention to causing a death in section 302 of Indian Penal Code.
The punishment for murder in section 302 of IPC. Whoever commit murder shall be punished with a death or imprisonment for life and shall also be liable to fine. There are some related cases. Arjun Mike versus State of Bihar. It is perfectly true that in a murder trial, when an accused person stands charged with the commission of the offence punishable under section 302, he stands the risk of being subjected to the highest penalty prescribed by the Indian Penal Code, and naturally judicial approach in dealing with such cases has to be circumstances and careful in dealing with such appeals or reference proceeding where the question of confirming a death sentence is involved. The court has to deal with the matter carefully and to examine all the relevant and material circumstances before upholding the conviction and the confirming sentence of death. There is another case too for ruling this appeal. The Maseji versus State of UP. In dealing with such appeal or reference proceeding where the question of confirming death sentence is involved, the High Court also deal with the matter carefully and to examine all relevant and material circumstances before upholding the conviction and confirming the sentence of death. All argument argued by the applicant and all material information placed before the High Court on their behalf must be scrutinized, examined and considered before a final decision is reached. The fact that 10% had been ordered to be hanged by the trial judge necessarily imposed a more serious onerous responsibility on the High Court in dealing with the present appeal.
According to International Human Rights, on 31st July 1979, there was indeed a dispute between Basant Singh and Darshan Singh, but there was no proof and no witness has seen and heard anything Bachchan Singh killing his neighbor Basant Singh.
In case of Atmaram versus State of Maharashtra, on the conclusion of the trial, the lead judge acquitted them of all the charges and agreed. Thereby, the respondent, the State of Maharashtra, preferred appeal. And the appeal High Court acquitted of the appellant of 8 others, and the High Court find that it has been reappraised the entire evidence and given cognizance so far as they related to the acquittal of the appellant.
Bachchan Singh has been convicted for the murder of his wife under section 300 of 2 of IPC. Bachchan Singh served 14 years in prison. After his release, he resided with his cousin Hukum Singh and his family. However, this living arrangement was objected by his wife and their children and cousin on July 4, 1977. The appellant committed an atrocious act by murdering 3 out of 4 children of his cousin using an axe.
But in that case, Bachchan Singh was provoked by Darshan Singh, and Darshan Singh had insulted Bachchan Singh and his family. But there doesn't seem to be such solid evidence, and there is no witness who can see it all and witness with his own eyes, who can tell when and where the murder took place.
Bachchan Singh was thus convicted for the offence of committing the murder of Desai Singh, Durgabai and Veeranbai by the Session Court. He was given the death penalty under section 302 of the IPC. He appealed to the High Court. However, the court dismissed his appeal and upheld the death sentence.
Sir, some factors is the punishment short are unconstitutional. The death penalty is unconstitutional as it violates the right to life and personal liberty guaranteed under Article 21 of the Indian Constitution. Second, arbitrariness. The death penalty is arbitrary and discriminatory in its applicant and has been applied disproportionately against the poor and marginalized. Inhuman. The death penalty in the human and cruel punishment and violates the fundamental rights of the accused. Possibility of reform. Bachchan Singh could be reformed and rehabilitated, and the death penalty was not necessary to protect society.
There are relevant cases of Machi Singh versus State of Punjab. The Supreme Court explained the majority and aggravating factors and also give the circumstances related to the institution of the respective punishment. In the aggravating factor, in murder should be pre-planned and extreme brutality or murdering a public servant or of the duty. And in the mitigation factor, the court considered the circumstances of the offender along with the circumstances of crime.
Here are some relevant case. Ramesh Babulam Dosi versus State of Gujarat. The appeal under section 302 of the IPC, whereby it was the acquittal of the appellant while upholding the appearance of 3 of others who was arranged with him. And Bachchan Singh must have proved that the act of causing death was necessary and reasonable in the that circumstances after the debate with the Basant Singh.
In the case of Mosari versus State of UP, in dealing with such appeals or reference proceeding where the question is confirming the death sentence is involved, the High Court also to deal with matter carefully and to examine all the relevant material, circumstances before upholding the conviction and confirming the sentence of death. All argument urged by the appellant and the material infirmities prevailed before the High Court on their behalf must be scrupulously examined and considered before a final decision is reached. The fact that 10% had been ordered to be hanged by the trial judge necessarily imposed a more serious and onerous responsibility on the High Court in dealing with the present appeal.
The defense cited international human rights laws and argued that the death penalty was a violation of these laws They also argued that the death penalty was not an effective deterrent and that there was no evidence to support the claim that it prevented others from committing similar crimes. Sir, after this matter is no conclusive fact that my client has killed Basant Singh.